Thank you. Be seated. Good morning. Now is the time set for oral argument in cause number CV17-0611, National Tax Lien Redemption Services, LLC et al. Versus Diane Boshian. Is that correct? Boshian, thank you. Sweeney. For everybody's information, these proceedings, as is the norm, are both being both audio and video recorded. So within a couple of weeks, if you want to see how you did and do whatever is appropriate to do with that, feel free to check yourselves out on YouTube. Counsel, each side, as is his standard course, will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know, as I'm sure you both are aware, how much time you have left. And for the appellate's benefit, if you wish to preserve any of your time for rebuttal, we'd ask that you let us know. We will try not to eat up all your time. However, ultimately, as is standard course, your reserving rebuttal time will be up to you. We have reviewed the briefs and conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument. You might want to keep that in mind when you figure out how you want to structure your argument time today. When you come to the podium, for both of you, we would ask that you state your name and who you represent so the record is clear in that regard. And with that, counsel for appellant, the podium is yours.
Thank you. For the record, my name is Richard Treon, and I, together with Attorney Jim Crook, represent appellant Diane Sweeney. Unfortunately, Mr. Crook has had some health challenges recently and is ill this weekend and under doctor's care, not able to be here today, so I get to argue the appeal, which I'm happy to do. I handled the case on the trial court level and also participated in the preparation of the brief, so I feel perfectly prepared to present the argument. We request the court in this appeal to reverse the trial court's denial of Diane Sweeney's motion for Rule 60C for relief, where she asked the court to set aside the judgment that was entered against her on October 9, 2012, because she had never been served with process, either directly or constructively or through any method or means known to the law. As a consequence, the judgment is void. The court had no jurisdiction over her, and as a matter of law, must be set aside. In addition, the treasurer's deed that was issued pursuant to that judgment also is void because it cannot issue if there is no jurisdiction over the person the judgment is being entered against. So we ask this court to reverse the trial court's decision in that regard. The court will notice in reviewing the minute entry in this regard, the court hardly spent any time at all talking about the subject of service of process, and then only in relation to how it affected Diane, derivative of her husband, but not because...
And what did you just say, counsel? I'm particularly interested
how it
in that
affected
issue.
Diane, derivative of the conduct of her husband. And under the law, her husband cannot bind her to service of process in this case.
And what law is that, counsel? Can you give me a statute?
Well, the rule is 4F. It's the acceptance of service. Rule 4F, Arizona Rules of Civil Procedure. And under that particular rule, in order to get service, you have to have the person who is being served by somebody else accepting service for them, here Tom, in writing, give that person authority to accept service of process for them. No such writing was given in this case by Diane. In addition, the evidence is that Rule 4F was not complied with in any respect. And just to back up the reel a second, nor was a Rule 4D1 related to service of process on an individual. Diane was never served individually. Defendants don't claim, the appellees do not claim that she was served individually. Diane, you had a process server who attempted to serve her. The process server filed an affidavit of attempted service. He was not able to serve her. So there was no service on Diane, period. The whole jurisdiction issue centers around Rule 4F and the law as relates to Rule 4F. You asked about the law. State Farm versus Long holds that a husband cannot accept service of process for the wife without a written acceptance as her agent, simply because he's her husband. The spouses each have independent rights, and here the appellees did not, National, the underlying company that got the judgment, did not respect Diane's rights. All the dealings Nationals had in this case were with Tom Sweeney, and then only by email and by telephone, never by in-person meetings. So what happened is a document entitled Acceptance of Service, Settlement of a Lawsuit, and Stipulation to Entry of Judgment, authored by Mr. Peter Sweeney, who represented National, was sent to Tom, and it was sent by a member of National who was a tax lien redemption company that had the tax lien on the property. Diane had no idea the taxes were in arrears. Diane had no idea Tom was talking to the National personnel.
When did she become aware of the foreclosure or of some formal process that would result in a foreclosure?
Thank you, Judge. Diane did not find out until late September of 2014 in a meeting with me that, contrary to her prior belief that she learned in July of 2013 when she and her 100-year-old mother-in-law were evicted from the house, that she then thought Tom had lost his house because he had problems with his creditors. This is a third house that he'd lost in their marriage because of problems with creditors, and that was her understanding. That's her sworn testimony. Because of the companion case of Rivers Treon, I was involved in litigation with National and with Premier and with the lenders and other interveners related to the validity of the Rivers Treon deed of trust. That had been entered into back in '86 and '88. So I met with Diane in late September of 2014 to find out if she had any of the documents left, because it's been 28 years and we had none of the documents left that went back to that transaction, and also ask her what her recollection was of the events. At that time, she knew nothing, and I told her at that time that Tom had actually signed a document on her behalf. I showed her a copy of it and asked her, "Is this your signature?" "No, that's not my signature." And the evidence is that after that meeting, she went outside and she slapped Tom and threatened him with divorce because she had no knowledge prior to that time how she lost the house.
So what? First of all, I guess you're not claiming any privilege. I can ask some questions like, what specifically did you tell her?
What I told her was that, first of all, I told her that I was involved in litigation because of the fact that Tom had not paid the taxes, and there had been a case that went forward and went to, I probably used the word judgment. I'm not going to try to say I didn't, but truthfully, I don't remember what I said in that regard. It was at a restaurant. What I mostly wanted to find out at that point was what happened here, because I had no knowledge either. And so I wanted to find out, what do you still have by way of records? What do you still have by way of any information I could use to support my case against these parties? At that point in time, I showed her the acceptance of service because she wanted to know what had happened. And she had, Tom hadn't even told her up to that point in time he had signed her name. And I said, is this your signature? No, it's not. And Tom, who was there, admitted he had signed it, and he claimed he did it somehow to protect her. But that's the first knowledge she had of anything related to this case. She had no knowledge of the judgment involved until late August of 2016, after she was noticed for a deposition by Premier to be taken by the title company lawyers, and she had to have a lawyer for that deposition. I agreed to represent her pro bono. At that point, I told her about the judgment, and I told her about the history of her service of process or lack thereof. And it was at that point in time she decided she wanted to get her own lawyer. Within 60 days, she hired a lawyer, and she filed her Rule 60C4 motion.
So the distinction between those two dates, your argument, is that in 2014, Ms. Sweeney generally understands things have not gone as planned, and that there's a foreclosure, but she's not aware that there's a judgment, and that doesn't happen until 2016, and that's the significant date that we should start to measure or assess any delayed reaction?
Sure, no, that's my recollection.
So I guess my question is this: what specifically was the difference in knowledge between 2014 and 16 that would require a court to begin measuring what would be some repudiation or some conduct in 2016 rather than 2014.
The 2014 late September conversation was all about what she recalled about the Rivers Treon dealings back in 86, 88. Do you have any more documents? No, I don't. And by the way, she says to me, what's going on? And I explained to her at that time that Tom, who was actually there, had lost the house because she was under the impression he lost it from creditors. Tom had lost the house because he hadn't paid the taxes. There was a foreclosure of it. I knew nothing about it. She knew nothing about it. And I showed her the acceptance document because the other side claimed that was her signature. She said, that's not my signature. And that's where she got very, very upset at Tom and emotional, and the meeting stopped very shortly thereafter. So there really wasn't any focus on the issue of judgment. But let me follow up on that because that's a very important point. If you stop and analyze what they're trying to argue, they're trying to say that she had knowledge of the judgment in late September of 2014, and at that point, Rule 66 somehow or another comes into play and says that even though she wasn't served, even though the judgment was void, even though the trial court had no jurisdiction, she loses her property because she didn't do anything after September of 2014.
And then she waits 2 years to do anything about it.
Yes, she does. But I understand your concern in that regard, but let me explain the timeline. It's very important.
Well, let's start with an earlier point in the timeline and then work forward to that.
Okay.
For how long has your firm represented Ms. Sweeney in any way in connection with this house?
We never, as a firm,
as far as I can tell, it based on the record in this and its companion case, it's been since the 1980s.
Since 1986, when James Rivers loaned $120,000 to Tom and Diane Sweeney, I represented Tom and Diane and Jim in that situation with full disclosures. I was simply facilitating a loan by one client to another client.
And we'll have an opportunity to get into all that, but if I understand correctly, your firm represented both Tom and Diane for decades in connection with this house.
That's not accurate.
Okay. Can you correct?
Well, because we didn't represent him from then on. Might have represented Tom a few times in regard to various debtor creditor matters that came up, but I never represented Diane again after that, and I didn't represent her in the deposition except pro bono. So, and I'm only involved in this matter at this point in time because Mr. Cook is not able to argue, and I made a special appearance at the evidentiary hearing because the lawyer who she hired to represent her in Rule 60C4 motion was only there for the motion itself, and she prepared a motion, she filed it, she argued it, and then the court decided they had to have an evidentiary hearing because counsel urged a Section 66 hearing.
Okay, so fast forwarding to the time then between 2014 and 2016.
Okay.
Why the delay? I mean, if one learns of a situation as you've described and has the reaction to it that you described, it seems odd that it would take 2 years to seek to do anything about it.
From her point of view, she'd lost the house, she had no money, she had no lawyer. I didn't represent her. I was adverse to Tom at that point in time because I'm finding out facts that he, did me, so to speak, as well as her. And so I'm not in there to represent Tom and Diane going forward from there.
But when you say that Tom is contrary to you at this point, he's opposed to you, are you talking about as you're in your position as a guarantor of that money?
No, he's contrary to me at that point in time because he failed to tell me he hadn't paid the taxes. He then allowed this case to go forward without telling Diane or me anything about what was going on, and allowed the judgment to be entered and hired an attorney, Jennifer Wright, to come into the court, and never told her that Diane didn't sign the document, Diane's signature was forged, never gave her the truth, didn't tell Judge Delamonte the truth about what happened, and Tom never told me.
And I'm sorry to ask, this is a very unconventional fact pattern, and I don't want to have anything wrong. Do you have an interest in this house? I
have no interest in the house whatsoever, Your Honor, except for the deed of trust.
How can you not have an interest in the house but have an interest in the deed of trust?
Well, I mean, technically...
Claim against the house.
Exactly.
It's filed against the residence.
I guess I was being lawyer-like in my answer. I have an interest in the deed of trust. Yeah, I admit that freely. That's what the next part of this case is about. have an interest in the deed of trust. But I mean, there's no obligation on me under the law as it relates to Diane's rights to go forward from October of 2016 to 2014, 2016. But if I could just have a moment to explain why this is true.
Well, and I'd like to let you do that, but I need to jump in with one more question.
Okay.
If you have an interest in the deed of trust,
Yes, I did.
representing Diane, who's trying through this process ultimately to revive some portion of her interest in this property.
Correct. And thereby reinstate the
Adverse
deed
to
of trust.
Diane? Are you not adverse to Diane?
No, because that would have the effect of reinstating the deed of trust. I'd be right back exactly where I should have been if Tom had ever told us the truth about what was going on back in 2012.
But if you lose this case and win the one that's going to be argued in a few minutes, doesn't that disadvantage Diane and advantage you?
It doesn't disadvantage her at all. I mean, I had nothing to do with the fact that she didn't get notice from her husband about the fact that there was activities going on between him and her in connection with him and the tax lien holder, and that somehow or another, I am not I'm as much a victim of Tom in that regard as she is. I didn't find out until this litigation, until Rivers was served in 2014 on February 12th, 2 years after he was served. The lawsuit was filed. That's when I found out. As a matter of fact, I was in trial in Superior Court in a bank robber case. And as a consequence, I didn't file an answer in that case until a couple weeks after Hendricks, the lawyer for National, got in touch with me and told me what was going on. But I know what you're concerned about, Your Honor, and I want to deal with the issue of Section 66 because that's what you're concerned about, and whether or not somehow or another Diane or somebody slept on rights that represented her. If you understand the timeline, nobody slept on any rights whatsoever. What happened is the judgment's entered in October of 2012. Premier purchases in March of 2013. They do not give Diane any notice of anything. Premier's principal deals only with Tom in evicting Mom, Claire, from the house. In the 7 months that had occurred since judgment was entered, no notice was given to Diane about the judgment. No notice was given to Mom to get out. And in fact, if you look at the paperwork between Premier and the seller, National, you'll find that National made a stipulation of the transaction that Premiers could not go on the property and talk to the occupant who was in the property at that time prior to close of the sale, because they didn't want Diane to find out about the fact that they had never dealt with her because they only had dealt with Tom. All right, now we go forward from there. What happens thereafter? In July of 2013, the eviction notice is finally served by National, by Premier, and Claire is evicted from the house. Claire and Diane are told by Tom that you have to get out. We lost the house. He doesn't say it's for taxes. He needs Diane to believe it's another house lost because of his business problems and a creditor. So then I set forth the facts in a brief. I don't have time to go through all of them right now. But Diane learns nothing about anything. And then up in March of 2014, she has very serious health problems. She has 2 major strokes and 2 minor strokes. And when I find out about the case, what's going on, I can't come in and even talk to her because Tom won't let me talk to her because he doesn't want me to find out about the fact he didn't tell her the truth. And so I'm not able to talk to her clear out until October of 2014. What difference does that have regarding Section 66? The difference it has is in Section 66, they got to prove 3 things. One, she had actual knowledge of the judgment. The judgment then occurred back in October of 2012. The earliest you can impute to her knowledge is late September of 2014 from me. I didn't give it to her at that time, but I'll go along with the assumption. What happens then is that when they buy it in May of 2013, they then wait until the spring of 2014. They get a loan, a takeout loan on a purchase money mortgage, and they take out additional money to build a house. And that's what they did. They built the house. The house is ready for sale in July of 2014. When Diane finds out what's happened, she's faced with a situation where the house is sold clear back in May of 2013. The house has begun to build in February. The house is already built. And so she has to have shown under the 66.
What's she doing in 2015? We're almost out of time here, so I just want to get to the point. What happens in 2015?
she basically is living impoverished in a home with Tom. That basically she has no power, no money, no nothing.
But by your rationale, then she could move to set this aside in 2040.
She didn't know any of the facts in 2014. And
No, 2040,
well,
2050.
I,
No time limit on this motion. So at some point when your house has been sold, I think you've recognized through your citation to Section 66 that there is a diligence requirement to try and get a remedy. 2 years seems a long time if you believe you've been defrauded out of your home.
well, the key to the whole thing is that she had no knowledge, she had no power, she had no money, she had no ability to go forward. I am involved in litigation with Premier and lenders and the other interveners over the issue of the deed of trust. It has nothing to do with title of the property. The issue of title of the property doesn't come on the table until they notice her for her deposition, and they require her to sign a piece of paper saying that we're going to sell this property, and if any proceeds come out of this property, then you agree that you will not seek to get those proceeds until the court says who gets them. That's what tipped her off to the fact that she might have a claim. And that wasn't until the summer of 2016. I know it's offensive in a sense, the idea.
But you must have suspected. I mean, in 2014, the idea that she might have a claim never crossed your mind?
I had wondered about it from the beginning, but I am not her lawyer. I am not involved, and you cannot impute to her anything I did or didn't do. I wasn't her lawyer, and I was adverse to the Sweeneys at that point in time in a certain sense because of the fact that Tom had, the vernacular, screwed me too.
Are you her lawyer today?
I am here as a special appearance, just like I was in the trial court on a special motion.
So that's yes.
Yes.
Outside of this special appearance, are you still her lawyer?
Pardon me?
Outside of this special
No,
appearance
not at all.
today?
Not at all. And going back to Section 66, again, they have to show reliance on the judgment. They have to show reliance on her manifestation of an intent that she was not going to treat, that she was going to treat the judgment, the manifestation of intent to treat the judgment as valid. She never manifested an intent to them that she was treating the judgment as valid. She did nothing because she knew nothing. And after she found out what she found out late September 2014, she continued to do nothing because she wasn't going to do anything because she had nothing, no power, no money, no nothing. How was she going to unwind the situation? Her husband forged her name. How do you get out of that?
Counsel, in October of 2000, you keep talking about September of 14. In October of 2014, didn't she sign Tom's declaration that had been prepared for him? I assumed it was by you, averring that everything in the declaration was true, including that he signed the acceptance of service for her because of her poor health?
No, Your Honor.
That's not true?
What happened is that I prepared Tom's declaration, and Tom then got Diane to sign a declaration made up of 2 paragraphs that basically avers to his declaration. In her deposition, she explained the circumstances surrounding her signing her name on that declaration. She did not intend to aver to any of the facts that happened after 1988.
So she didn't verify that he had signed the acceptance on her behalf due to her physical condition?
Not at all, Your Honor. She did not. No, that's not the. If you read her testimony in that regard, you'll find that although Tom is saying those facts, those are all the facts that she never knew because Tom never told her. And the declaration that she signed is not a declaration swearing to the truthfulness of all the stuff that Tom knew. She basically is saying what she said. Now, I agree that 2-paragraph thing that was signed, had Tom had her sign, was not the appropriate the way it should have been. I should have said, I am averring only as to paragraphs 1 through 15 as relates to my personal knowledge. All the rest of it is stuff that Tom knew, but I did not know. And her testimony or deposition was, I did not know any of the facts beyond paragraph 15 at the time that I signed his declaration. I didn't know it until even the time of her deposition. So that's not a valid basis to find on an evidentiary basis.
Thank you, counsel.
that she's bound.
Thank you.
I guess I want to tell you.
Understood.
May it please this court, Scott Malm of the law firm Gust Rosenfeld on behalf of Geared Equity and 5780 LLCs. They've been known as the lenders throughout this lawsuit. With me at counsel table is Rick Cobb, who represents the owner, Premier Equity. Because we're on the same side, I will reserve just a few minutes, if I can, of my time in case he has anything.
You worked that out with him?
Yes.
Thank you.
The Superior Court Judge Talamonte held a full evidentiary hearing on the Rule 60 motion. He heard Tom and Diane testify, and he didn't believe their testimony. Their credibility was definitely lacking, particularly Tom, who now in court is saying, "Trust me now, Judge, I was lying before to you." That goes to the issue of credibility, and while you may find Mr. Treon's arguments here interesting, and maybe if you were in Judge Talamonte's shoes, you might have reached a different result, he exercised his discretion to deny the motion based on the evidence before him. And for you now, the role is to see, was it an abuse of that discretion? And if there's evidence in the record to support Judge Talamonte, then it wasn't an abuse of his discretion.
Counsel, can you answer my question that I posed to Mr. Treon? Did Ms. Sweeney aver to the truthfulness of the statements in Tom's statement, his affidavit, whatever?
Yes, she did.
And one of those was that he had signed on her behalf.
Yes.
And she said, yes, that's true.
Yes, and I can give you the exact citations. The 2014 declaration, the wording of the representation by Diane Sweeney, first of all, to point out, it seems to be the same typeset as the rest of the declaration, which we've been told was prepared by Mr. Treon. This doesn't look like it was Mr. Sweeney, Tom Sweeney, putting this added on for his wife to sign for some reason. And this has been waved around in the other lawsuit for the truth of the matters asserted therein to support the other issues. And here's specifically what it says above Diane Sweeney's signature. All the facts stated herein are true and accurate to my personal knowledge. And then continuing, I would swear to the truthfulness and accuracy of those facts. So she is specifically saying that. And then if you go to paragraph 18 of the declaration, it says, at the time that she, again from Tom's writing perspective, she, Diane, friends, I, signed the stipulation. And then the paragraph above that, paragraph 17, it says a stipulation was forwarded to me, Tom, and because of my wife, Diane's poor health, I signed for her. So it's 17 and 18 both talk about the signature. And then to go to the question that was asked a little while ago, does the 2014 declaration make reference to the judgment? Yes, it does. That's in paragraph 21 of the declaration, where it flat out says, she, Ms. Hendricks, who was representing National Tax at that point, got a judge to sign the judgment. So there's no question that a judgment has been entered as a result of that stipulation, which Tom has signed and she's acknowledged he signed as of 2014. If I could just go over, we talked, your questions to Mr. Treon were focused mostly on the spousal relationship, and there was plenty of evidence there, not only the declaration, but just a general delegation of duties that was testified, that Diane testified she had given to Tom. I also want to focus on the second agency relationship, which is the attorney-client relationship, not with Mr. Treon, but Jennifer Wright. Jennifer Wright appeared in this action in the lower court on behalf of Diane to try and set aside the stipulation and the judgment that was going to be entered. And she made an appearance on behalf of Diane. A lawyer's appearance on behalf of a client gives the court jurisdiction. And at least when a lawyer makes the appearance, there is the presumption that that lawyer has authority.
Counsel, one thing I kept looking for was any sort of declaration or something to tell me what Attorney Wright did or didn't do. You are here saying that she represented her, and the other side saying no. Has anyone asked her?
No, Diane Sweeney did not call Jennifer Wright
Did you?
to testify. No, because there's a presumption that she had authority. No, we did
So
not.
you acted on that presumption in not finding out the answer.
We have no reason to believe that Diane did not hire or did not have a lawyer, Jennifer Wright, representing her. We have no reason to believe that other than their side saying, no, she wasn't. So
Right, well, isn't that evidence? She says, she didn't represent me.
it is evidence. Is it clear and convincing evidence? And is it an abuse of discretion for Judge Talamonte to have found otherwise?
So if a lawyer just enters an appearance, let's say I enter an appearance for you tomorrow in some case, you have to prove by clear and convincing evidence that I am doing wrong, fraud, or certainly violating my ethical responsibilities?
Yes. That's what the cases say. There is a presumption, and the Arizona cases talk about the presumption. The Arizona cases don't talk about clear and convincing. I'll grant you that. That standard comes from many other jurisdictions. And one of the aspects of that would be, how would a person react when they find out that someone has made an appearance on their behalf? And the 2014 declaration states that Tom hired Jennifer Wright for Diane. And yet we have 2-year lapse before Diane comes in and says, no, she didn't represent me. She was not my lawyer. So that would be the evidence in the record that Judge Talamonte could base his decision to say, I'm sorry, that looks too fortuitous to you, Ms. Sweeney, that you're going to wait 2 years to object to a lawyer appearing on your behalf. I guarantee you, as soon as I find out that you, Judge, would make an appearance on behalf of me and I hadn't authorized that, I would do something about it. And my situation is, I'm a lawyer, I know those rules. Diane Sweeney also, having worked for the court, understands, and that was also before Judge Talamonte. She worked for the court for, I believe it was over 15 years.
But when did she become aware, if we're going to start, let's say this is a new clock, this is the attorney right clock, that an attorney had entered an appearance for her without her authorization? When did that clock start?
Well, at least by the signing of the 2014 declaration, because that appears in paragraph 19 of the 2014 declaration. Tom saying, to which Diane agreed, Tom, I then hired attorney Jennifer Wright to represent my wife. So that's in the 2014 declaration. And 2 years goes by before Diane Sweeney steps up and says, wait, she was not authorized.
But wait, the declaration avers to the truthfulness of the statement that the attorney was there.
Exactly, was hired for her, and there's nothing in the declaration that even suggests it was unauthorized. So you've got a couple of things going. You've got the statement that Tom hired attorney Jennifer Wright to represent Diane. You have no statement that that representation was unauthorized, and then you have Diane waiting 2 years to step up to the plate and say that was an unauthorized appearance.
But no one's spoken to Wright.
Not that I'm aware of, no.
There was never an attempt to make traditional personal service, correct?
My recollection is we weren't involved because that was national tax back in 2012. There was attempted service. There was an affidavit of attempted service, but they never accomplished that service on her at the home. That is correct.
Nor did they accomplish it on Tom at the home?
Correct. I do not believe it was accomplished either way. And that is why then the stipulation for judgment as part of that settlement process included an acceptance of service, because service of process hadn't been accomplished in the normal way. So they needed something signed to file to show that there had been an acceptance of service.
And you don't dispute that the acceptance was at some point fraudulent?
We accept that Tom signed for Diane.
Right.
We don't accept whether or not that was fraudulent, because when the 2014 declaration says Tom hired Jennifer Wright to represent Diane, and there's no allegation of it being unauthorized, and there's a reason for that, which was her health. And also, another piece of evidence that was before Judge Talamonte, national taxes principal, Mr. Crane, stated that Diane had said to Tom, who said to him, now there were no hearsay objections, so it was before Judge Talamonte, that Diane had said to Tom, fix this tax problem. So she was aware of the tax problem by one of the letters and told Tom. So
Aware of a problem is a lot different from being aware of a summons.
yes, and so, but to answer your question, we're not conceding that Tom committed fraud on his wife, because this fraud argument didn't surface until 2016, and so much had transpired that seems consistent with one spouse who had been delegated the responsibility for the property assisting the other spouse.
Did Tom not continue after the transfer of his ownership interest in the house to his wife? You with me?
Yes.
Did he not continue at her direction to take all actions in regard to the house?
Yes, and
He functioned as her agent in one regard or another, whether he
Yes.
had a continuing interest or whether he had no interest but was functioning as her agent.
yes.
How does that figure into all of this?
Well, that would be an example of the general delegation of authority that can apply in a spousal relationship. And in fact, that is the Gruber case from 1975, where it was the opposite. It was the wife who had been delegated the responsibility in general for a property, and a court upheld the wife's actions for the Dr. Gruber dealing with a lease. So you have a general delegation that can support this kind of agency relationship. You can even have the specific delegation, which is fix this problem.
And is that not what Mr. Treon said she told her husband? Fix
Yes,
the problem,
yeah.
take care of these taxes.
Fix this problem is a lot different from authorization to accept service, wouldn't it?
No, because the authorization to
I've been
accept,
told to fix a lot of problems in my life. I don't know that I've ever been authorized to accept service on behalf of someone outside a professional lawyer-client relationship.
the acceptance of service of process was part of the settlement. So in order to buy Diane more time to address the tax issues, the
Part of
stipulation was sign the
There could have
acceptance.
been a lot of things that were part of the settlement, but saying to somebody, fix this problem, does not necessarily connote authorization to accept service or to take any other measures to fix the problem. The settlement could have contained all sorts of onerous conditions that might not have been authorized because they might not have been perceived as a fix to the problem.
That is correct. And if we were in front of Judge Talamonte and the only evidence we had of the relationship of the parties was the double hearsay potential statement of fix this problem, I would agree with you. But that, in conjunction with so many of the other things that took place, there was enough for Judge Talamonte to find that Tom was Diane's agent for purposes of accepting service of process. I see that I have about 5-6 minutes left. Unless there are any more specific questions for me as the lender's representative, I also want to give time to my co-counsel.
Thank you, counsel.
Judge Swan, it looked like you were maybe...
I was just checking one thing. Give me just one moment.
Sure.
No, I think we're fine.
Thank you.
Good morning, Your Honor. If it may please the Court, I'd like to just focus briefly on the restatement section 66 and the delay in filing the motion to set aside.
Are we talking the October 2014 to 2016 delay? Is that what?
Yes, except that I'm talking the July 2013 delay. We all talk about it from 14, but it's really 13 because, as we mentioned, as my esteemed counsel mentioned, on page 17 of his brief, after Premier's demand to vacate, Tom, Diane, and Claire vacated the property in July of 2013. When Diane says she didn't know until 2016, I just don't know how that's possible because the record's pretty clear that she signs that statement in 2014, and she physically moves out of the house in 2013. And it's not 2 years, it's 2.5 or 3. I'd have to do the math real quick, but it's July of 2013. And also cited on page 37 of the brief by my esteemed co-counsel here is Diane's testimony when I asked her in deposition, can you explain why you delayed? And she said when the house was lost. To me, it was just lost. It was gone. And she goes on to say in her 2016 declaration, she confirms that, as far as I understood, I'd lost any legal rights to the property.
Knowing that there's a problem and that you've experienced a loss is a lot different from knowing you've been served.
Conceded, Your Honor. But I'm speaking just to the issue of, did she wait so long while we sat and litigated, while we were out there taking depositions, and she knew it because she'd had the conversation with Dick Treon in 2014 and signed documents. We're sitting out there litigating, and she's waiting from the time she moves out of the house. She has the meeting with Treon where he gives her the lowdown. She starts signing affidavits until 2016. Based on the Restatement 66 of judgments, when you sit and you delay that long, and you let us all sit out there and litigate, we're all thinking that she's going to accept that judgment. Then when she comes up in 2016 and files the motion to reconsider, that seems a bit late. And the only point that I wanted to raise before the tribunal this morning is that I don't think it's 2014 that we should be focused on. I think it's 2013. Are there any other questions that I can answer for you since I'm standing here?
No, we're good.
Thank you.
Well, counsel, talk to me about the Martin case, which says in the Rule 60 context that there is no time limit and that there's no such thing as unreasonable delay to move to set aside. How does that sort of blend with your argument?
Thank you, Your Honor. Certainly, the Martin case does say that there's no time, but if you look at the restatement, which has of course been adopted by Arizona, unless you've got a specific reference to the contrary, there is in fact read into the law a period of time whereby if you delay and you let other people think that you're going to accept the outcome, that in fact it can work as a forfeiture of your rights. And that's why the restatement section of 66 is cited in our moving papers.
Are they consistent, Martin and section 66?
I think they're part of a more full treatment of the law. If you look at Martin, it essentially says, look, if you don't get served, you don't get served, right? You got to forever, unless, and this is why restatement 66 is important, unless you know about it when you have to move out of the house in 2013. And unless you know about it when you meet with Treon and Mr. Treon in 2014 and start signing statements. Then at that point, when you read Martin and you read restatement section 66, the law essentially is, yeah, if you don't get served, you don't get served. But if you don't get served and you find out about it, and you wait 2-3 years, then there comes a point where you can in fact lose your rights.
And Martin says that.
Martin does not say that. The restatement section 66 does.
Do you think Martin and section 66 are inconsistent with one another?
I don't think they're inconsistent. I think restatement section 66 just adds to our knowledge of this area of the law in the sense that Martin just didn't go that far. If you'd had facts like that in Martin, it'd have been different, but you didn't.
Has there been any position taken in regard, a factual position taken by Mr. Treon or Ms. Sweeney in regard to why they would have moved out of the house in 2013 other than the fact that the house was going to be lost?
That is the only explanation, and there's never been any explanation of that to my understanding of the record. You can search the record forever, and I don't believe it's in there. You move out because you know you lost the house, and in fact, that is her testimony. The house was lost to me. It was just lost. It was gone. It was gone. It was gone. I think she said it 4 times.
And that was 2013?
Yes, sir.
All right.
Thank you.
Counsel, you have 1 more minute. Is there any other thing you want to finish up with?
Just one more thing to add to supplement what Mr. Cobbett said. Really, it's the idea of estoppel. The Restatement 66 talks about the basis for its reasoning is the concept of estoppel, and estoppel wasn't addressed in Martin, so I just wanted to add that how you can blend those two. Martin just is talking about a straight time period, whereas Restatement 66, which was by the Sprang case in 1990, recognized as good law, it just didn't apply in that fact situation because there wasn't an unreasonable delay. So we do have at least the Court of Appeals in the Sprang case recognizing Restatement 66 and the elements there based on the idea of estoppel.
Thank you.
Thank you.
Counsel, we thank you for your argument today. The facts in this case are sufficiently convoluted that it certainly helps to hear from the players. We are going to end argument at this time. and you will be hearing from us. So thank you. We're adjourned.